Perek Cheskas Abatim Daf Lamed Dalet, sponsored the Refuah Shlema for Binyamin Chaim ben Sora. Gemara discusses a case where one witness testifies to a 3-year chazaka. An occupant of property produced one witness who testified to his chazaka. Unquestionably, he cannot acquire based on his testimony. Abai and his Talmidim argued whether the occupant is required to reimburse his challenger for the produce he consumed. Abai's Talmidim compared this case to Nascha de Rabbi Abba. One snatched an ingot of silver in the presence of one witness. When accused, he admitted in court to the theft, claiming the ingot belonged to him. Suggesting his claim is true based on amigo, he could have denied snatching it, is insufficient grounds to believe his claim. He may not want to take an oath to refute the claim of the witness. There is no provision for an oath to support his claim the ingot belongs to him. Rabbi Abba holds, since he cannot swear, he must return it. The court cannot ignore a testimony of one witness just because his claim precludes taking an oath. The Gemara's case is similar. The occupant cannot swear to refute testimony of a witness he provided to support his claim to the property. Therefore, he has to pay for the produce he consumed. Abai rejected the comparison. The cases are not analogous. The witness who testified to the snatching of the ingot opposed the defendant, whereas in the property dispute, he supports him. The verse in the Torah, Lo yakum eid echad beish l'chol avoin u'l'chol chatos, Chazal infer from it, one witness cannot impose a monetary obligation, but he can obligate him to take an oath. This means wherever two witnesses can impose a payment, one witness can impose an oath. Since the snatcher is unable to take an oath, he must return the ingot. However, an additional witness in the property dispute would not require relinquishing his rights. It would support his claim. Although he cannot remain on the property, he is not required to pay for the produce he consumed. Abai explains a hypothetical analogous case. It is the challenger, rather than the occupant, that provides one witness who testifies he consumed produce for 2 years. Since the occupant claimed the property, admitted consuming the produce, he cannot take an oath refuting the testimony of the witness. Since he cannot swear, he must pay. The Gemara brings a machlokas regarding the court's conduct in a case where two dispute ownership of a boat. Neither were in possession of the boat or able to prove their claims. One litigant requested the court impound it while he proved his claim, preventing his opponent from selling it in the interim. Rav Huna held the court should impound the boat. Neither party stands to lose. In the event he does not prove his claim, the court will release it again. Rabbi Yehuda disagrees. The court cannot release impounded property until it determines the true owner. Since his request may be employed to deprive his opponent, it is preferable for the court to adopt a hands-off policy of kol dalin gevar. Let the stronger prevail. The true owner most likely will prevail physically or legally. The halacha follows Rabbi Yehuda. The courts do not seize disputed property. In the case where both litigants requested the court to seize the property or they seized it in error, they do not release it. If you're enjoying Daf 5, please click on the link below, subscribe, and become a sponsor. Have a good Tvach, a Shavua Tov.